TDS in income tax is getting more and more complicated by the day, and from 1st July 22 a new provision section 194 capital R is being introduced on business promotion expenditure. Let us understand 194 capital R in the backdrop of the circular issued on 16th June 22 by the CBDT, circular 12/22. The impact, issues and challenges in implementing 194R, along with the interplay of TDS under 194R vis-a-vis input tax credit on business promotion expenditure under GST in the light of the precedents. First, section 194 capital R requires a deduction of TDS at the rate of 10% by any person where any benefit or perquisite has been provided to a resident where the value or the aggregate value of such benefits or perquisites are more than 20,000 rupees. The TDS has to be deducted even before provision of such value of benefits or perquisites, whether paid in cash or in kind or partly in cash or in kind. There is an exemption for those individuals or HUF which are under business or profession and where the gross receipts of the business or profession is less than 1 crore or 50 lakh as the case may be. These provisions would be applicable from 1st of July 22 and the threshold of 20,000 rupees would be calculated from 1st July 2022 and all the benefits or perquisites provided post 1st July 2022. Now let us understand the impact, issues and challenges in this regard. First, and the most important, is that the recipient of these benefits or perquisites would have to disclose these benefits or perquisites and offer them for taxation under section 28 clause 4 of the Income Tax Act in the head business or profession. Even if there is a provision of a benefit or perquisites in the form of capital assets like an incentive by way of a fridge, TV, AC, etc., would be required to be disclosed under 28(4) and offered for taxation by the recipient. Yet, whether or not it has been offered for taxation or disclosed under 28(4) by the recipient or not is irrelevant, and the deductor or the provider of the benefit or perquisite has to deduct TDS under 194 capital R. Therefore, most of the recipients as of now who are not disclosing these benefits or perquisites in their return of income, now this TDS would appear in their form 26AS and they would have to disclose these benefits or perquisite and offer it for taxation under 28(4) under the head business or profession. Cash discounts, sales discounts would be benefit or perquisite, but it is kept outside the purview of 194 capital R or 28(4). However, free samples would find its way under 194R and benefits or perquisites under 28(4) of Income Tax Act. But 1:1 free or 1+1 free or buy one get one offers would not be considered to be benefits or perquisites. Very important again, there has to be a nexus with business or profession for attracting provisions under 194R or 28(4), where there is a voluntary or gratuitous gift. Then if there is no nexus of the gift with business or profession and it is purely on a voluntary, gratuitous or personal basis, 194R or 28(4) would not be impacted. One very important clarification in this circular, and which would really impact businesses going forward, is implication of 194R on reimbursements. Now, this is a very important clarification. Whether or not it would be challenged is a question to be asked, but the CBDT has clarified that in case of reimbursements also, it may be impacted and TDS under 194R could be applicable on certain reimbursements also. For example, say you hire a consultant and the deal is that the travelling, airfare, conveyance, hotel stay of the consultant would be provided by you as a client. The consultant travels, stays in the hotel and provides the bill to you, and you make a reimbursement on actuals as per the bill. The question is whether 194 capital R would be applicable and TDS of 110% would be applicable on these reimbursements or not. It has been clarified that these reimbursements would also be impacted by 194R if the bills of the service providers, that is the bill of the hotels or the airlines, is in the name of the consultant and not in the name of the company. Only if the bills are in the name of the company, then 194R TDS would not be applicable. You draw corollary to GST also, and such reimbursements were not considered as liable for GST based on Rule 33 of the CGST Act, considering these as reimbursements under pure agency. Friends, it is important to understand that a clarification by the CBDT in this regard, why it would not be applicable mutatis mutandis to GST, but there is a condition under Rule 33 of the CGST which requires that the title to the goods or services should be in the name of the principal, and an analogy can be drawn that to prove that the title to the goods or services is with the principal would be proved only in case the bill of the airlines or hotels would be in the name of the company and not in the name of the service provider, which is a consultant in the instant case. This would be a major change in the business processes which required restructuring after 1st July 2022, which is also the GST day, marking 5th year of GST. Another important impact of 194R is on dealer conferences. Sometimes dealer conferences, foreign tours are provided to certain dealers for achieving certain targets, right? So, if certain dealer achieves certain targets, they are taken to a foreign trip and the expenditure is booked as dealer conferences. Well, it has been clarified in this circular that in case the dealer conferences are pure educational, for example, for introduction of a new product, and it is for all the dealers and not a select few, then only TDS would not be applicable. However, if the dealer conferences are for select few dealers for achieving certain targets, and where there is a clear benefit or perquisite which is coming out of the dealer conferences, then section 194R TDS would be applicable on the value of benefit or perquisites provided by such dealer conferences or foreign tours. Friends, another impact or issue under 194R is that it negates various precedents. In the case of David Dhawan, the Honorable ITAT Mumbai had held that where the family members accompany a professional for few days on a business trip, then it would not be considered under 28(4) and it would not be considered as a value of benefit or perquisite. However, this circular dated 16th June talks on contrary lines. Similarly, in the case of Mahindra and Mahindra, the Honorable Apex Court had held that where the perquisite is in cash, it would not be considered under 28(4). However, this circular and 194R negates this case law, and even where the perquisite is totally in cash, section 194R TDS would be applicable. There can be various other examples which are embedded in the PPT in this video. The same are also embedded in the articles which you will find on our website taxconnect.co.in. Important is, lastly, under GST, in the case of Page Industries, it has been ruled by the Honorable Advanced Ruling Authority that where mannequins and business promotion brochures etc. are provided by the manufacturer to the dealers, then input tax credit would have to be reversed or GST would require to be charged on the value of such business promotion materials provided by the manufacturer to the dealers. Well, our view is a little different under GST, which we have expressed in our video earlier. You can look at our channel and we have various videos on this. However, in the instant case, I would say TDS under 194 capital R may be applicable based on this circular on the value of expenditure done for business promotion. So 194R has to be read closely with GST, and business processes to the extent of business promotion expenditure need to be restructured by the businesses from 1st July 2022. Please do keep on logged on to this channel, and please do share the videos. We would come out with more videos, and the series would continue on input tax credit under GST on this channel. Keep watching. Thank you very much.